Today is February 24th. It's the 55th day of the year, and this is the On This Day podcast. If you've been listening since the very first day, some of this may sound a little familiar to you. If you've joined after that, it'll all be new. Either way, I hope you enjoyed today's show. Brand spanking new episodes coming very soon. Two big Supreme Court cases are decided on this day, February 24th. The first case decided on this day in 1803 is Marbury versus Madison. At that point in time, the Supreme Court has only been in existence for a few years, established in 1789 as the final arbiter in all judicial cases of a federal or interstate nature. Since then, the court has essentially been defining the extent of its authority with each case it decides, as well as with the cases it passes on. Marbury versus Madison is one of the first landmark decisions the Supreme Court hands down. Let's see how quickly I can summarize the facts of the case. After the election of 1800, William Marbury is a federal appointee, one of a dozen or so appointed by outgoing President John Adams, who have yet to receive their commissions from the Secretary of State. The outgoing Secretary of State, John Marshall, goes on to take his position as Chief Justice of the Supreme Court. And incoming Secretary of State, John Madison, still does not give Marbury and all their commissions. So Marbury takes it to the court. It's a sticky situation for the newly seated Chief Justice Marshall and the fledgling Supreme Court. They run the risk of looking weak if they don't take the case, or even if they do take the case, fined for Marbury and Secretary Madison ignores their decision. Well, they take the case, fined for Marbury, and Chief Marshall delivers a very carefully worded opinion on this day in 1803 that firmly cements the doctrine of judicial review. According to Cornell University Law School, quote, "Judicial review is the idea that the actions of the executive and legislative branches of government are subject to review and possible invalidation by the judicial branch. Judicial review allows the Supreme Court to take an active role in ensuring that the other branches of government abide by the Constitution." The decision delivered on this day in 1803 is essential to the separation of powers that keeps the United States federal government in balance. The other big Supreme Court case on this day is decided a few years later. In the 1970s and 80s, Jerry Falwell is a prominent televangelist concerned with the moral decay of society, and Larry Flynt is a magazine publisher pushing the boundaries of bad taste. Flynt is a handy target for Falwell. No doubt, Jerry Falwell believes Flynt is contributing to that moral decay by peddling smut. But his vocal opposition to Flynt is also good publicity for him and for his political organization, the Moral Majority, and he never misses a chance to voice his outrage. In 1983, Larry Flynt targets Falwell with a parody advertisement he publishes in his magazine Hustler. The ad is a somewhat amusing yet blatantly offensive fake Campari advertisement, depicting the Reverend recalling his first time, suggesting that Falwell had Oedipal proclivities towards his mother as a young boy that he manifested in the backyard latrine. Falwell sues Flynt for $50 million for libel and intentional infliction of emotional distress. When the case goes to trial, Flynt wins on the libel claim but loses the emotional distress claim with damages awarded to Falwell in the amount of $150,000. Flynt appeals the case to the U.S. Supreme Court, and in late 1987, the court hears the case. On this day in 1988, the Supreme Court decides 8-0 in favor of Larry Flynt, stating that though the ad can be considered tasteless or offensive, as parody, it is protected speech under the First Amendment of the Constitution. Chief Justice William Rehnquist writes the court opinion, noting that the First and 14th Amendments prohibit public figures and public officials from recovering damages for the intentional infliction of emotional distress resulting from the publication of a caricature, such as the Campari ad parody of Falwell, without showing in addition that there is a false statement of fact made with actual malice. And since this parody cannot reasonably be interpreted as stating actual facts about Falwell, no one in their right mind believes that the statements made in the ad are real. Flynt's First Amendment protection of speech cannot be denied. Rehnquist writes, quote, "Outrageousness in the area of political and social discourse has an inherent subjectiveness about it, which would allow a jury to impose liability on the basis of the jurors' tastes or views, or perhaps on the basis of their dislike of a particular expression, and cannot, under the First Amendment, form a basis for the award of damages for conduct such as that involved here." It's a landmark decision, possibly one of the most important First Amendment decisions to come out of the Supreme Court, even if the emotional distress of a public figure is intended. Outrageous statements of false fact presented as the parody or satire of public figures are protected by the First Amendment. Any limit on such speech, no matter how doubtless gross and repugnant it may be, would have a chilling effect on free speech. Almost 10 years after the decision, Jerry Falwell and Larry Flynt appear on Larry King Live together. It's the first time either has been in the presence of the other since this day in 1988 in the Supreme Court. Soon after this meeting, they travel the country together, debating each other on college campuses, discussing the First Amendment and the limitations, if any, of decency on free speech. Later, they exchange Christmas cards, photos of grandkids, and, no kidding, dieting tips. And they discover that though they may be diametrically in opposition on issues of politics and morality, they actually have a lot in common. And they become friends. In the summer of 1954, a 23-year-old Catholic woman named Joanne Scheibel becomes pregnant with a child with her boyfriend Abdullah Fattah Jindali, a Syrian Muslim. Joanne's parents don't approve of the relationship, and the couple feel they are too young to wed. So Joanne has the baby on this day in 1955 and gives it up for adoption. This is the 1950s. Single motherhood is not supported by society, and abortion is illegal. So adoption is the best choice, the only choice for Joanne. And though she is giving up her child born on this day, she still wants the best possible future for him. She wants a well-off, university-educated Catholic couple to adopt her baby boy, assuring that he will be well taken care of and receive a college education. When that couple changes their minds and decide they want a baby girl instead, another couple is found for Joanne's baby. This second couple, however, are blue-collar. They didn't graduate college, and Joanne refuses to give them her boy, going to court to prevent the adoption until they promise her they will provide him with a college education. When Clara and Paul Jobs take their new baby boy home, they worry that he will be taken from them. They worry they aren't good enough parents. They worry they've made a mistake. Their worries are for nothing, though. Their son, Steve Jobs, born on this day in 1955, grows up feeling deeply loved, indulged, and blessed to have them as parents. Years later, Steve Jobs will meet his birth father and not even know it. He meets him in a Syrian restaurant Jindali owns, neither of them aware of their biological connection to each other. And Jindali will boast of having a luminary such as Steve Jobs in his establishment. But the biological connection is all they share. Steve Jobs, born on this day in 1955, will tell biographer Walter Isaacson that he never liked to hear his adoptive parents referred to as such. Paul and Clara Jobs, in his words, were his parents 1,000%. There are 311 days left in the year.